Hello and I welcome you to my YouTube channel Logical Upgradation. In this video of Logical Upgradation, I will be dealing with one very key issue, that is Criminal Procedure Identification Act 2022. I have already uploaded one video on same subject matter. So this video is the next part or probably the last part on the same subject matter. So let us get started. The Union government's proposal to enable the law which authorizes the state and police to collect the biological and biochemical samples of the prisoners has raises some serious questions and apprehensions, since this legislation, this law has a lot of potential to affect us going in a long run. So the Union of India, the Government of India has proposed this bill on the table of the House of the Parliament on 28th of March 2022. So recently on 6th of April it passed by both the Houses of Parliament, and now the bill is pending for the assent and consideration of the President. So let us get started what exactly this bill is about, and I will be arguing for the bill and against the bill, merits and demerits. I will try to explain you what are the pros and cons of the bill. So let us get started. Firstly, if I suppose to argue against the motion, that is against the bill, the opposition members are harping, stressing and emphasizing upon the privacy issue. Why privacy issue? Because the Union of India has enabled the state authorities, law enforcing agencies to collect the biological and biochemical samples of prisoners. Measurements that includes physical, biological samples, your footprints, fingerprints, palm impressions, and also behavioral attributes. What exactly this behavioral attribute is about? It means your signature and handwriting samples. So by this way, opposition members are of the opinion that government is increasing its surveillance propaganda agenda. The opposition members clearly stated in unanimity that this bill is illegal and draconian. I will try and explain why the opposition members are saying so. The next content, the next point of the opposition member is that the assent or the consent of the prisoner is irrelevant, is not subject to any consideration. The term prisoner is very wide connotation. Prisoners includes not just convicts, not just accused, even a detainee, a person who got detained under the Preventive Detention Act. जो कोणी अटक केलेला नाही, ताब्यात घेण्यात आलेला आहे, अशा व्यक्तीला देखील बायोलॉजिकल अँड बायोमेट्रिक सॅम्पल्स देणं अनिवार्य करण्यात आलेलं आहे. So let us get ahead with the opposition member view. They are of the opinion that this grossly violates the privacy issue, and it also violates the Supreme Court judgment in K.S. Puttaswamy. In this judgment, the Honorable Apex Court has held that fundamental right to privacy is also part of Part 3 of the Constitution, which is a fundamental right from Article 12 to 35. So right to life includes right to privacy. So there is a gross breach of privacy is concerned. So opposition members are harping on privacy. Let us get to the next connotation or next point of argument of opposition, which says that it not just violates privacy, it also violates Article 20 subclause 3 of the Constitution, which is again a fundamental right because it falls within the Part 3 of the Constitution, that is Article 12 to 35. So Article 20 subclause 3 speaks for protection against self-incrimination. What is this about self-incrimination? So the Constitution has given to every person and citizen protection against self-incrimination. Means no one can impose you, no one can compel you to give evidence against yourself. So this has a connotation of incrimination. Further, there are other concerns too, such as the means and the modes in which the sensitive data is collected, preserved, disseminated and destroyed. They are also harping upon the issue that without making any privacy protection laws, government is in a hurry to pass this law. So they are suggesting that you should send this legislation to select committee for further scrutiny, deliberation and discussion. Further, there are very vague and ambiguous terms and terminologies in the bill, such as law enforcement agencies. By this virtue of legislation, the police authorities can share your personal data with law enforcement agency. Who are these agencies? Who are law enforcement agencies? It is not defined. It is not clarified. Moreover, what happens? Who is in charge? The officer in charge of collection or storage of such sensitive data, by on part of his mistake or negligence that data got breached, what modes or kinds of punishment state government will impose on officer, that is also not clarified. So there is a risk that your personal data, private data can be shared, can be disseminated, can be destroyed with any agency which is not authorized to do so. So there are quite apprehensions, and the opposition members are raising their voices and concern against this bill. Now, if I suppose to argue in favor of the bill, what are the points and contents of the government to support the said legislation? Government of India is of the opinion that the sole purpose and object of this legislation is to increase the conviction rate in the country. What is this conviction rate is about? Conviction rate is basically such a rate. Conviction means when a court of law, after a due process, finds someone guilty of any particular crime or offence, so you can say the court has convicted that person. On the contrary, acquittal, when court finds somebody not guilty after a due procedure, so you can call him that he got acquitted. So the sole purpose and object of the government, the primary purpose rather, to increase the conviction rate in the country, which is extraordinarily very low. So the next point of argument on government front and side, that it will modernize the policing agencies, it will advance the investigating agency in taking the samples of the prisoners. In a way, it will help the prosecution, and indirectly it will help to improve the conviction rate in the country. The next point of argument by our Union Home Minister, that the previous bill of prisoners identification 1920, which seeks to replace this present bill, seeks to replace the old bill of prisoners identification act 1920. So the government of India, our Union Home Minister said in the parliament that the previous bill kaal bahya ho gaya hai, it has got outdated, it is not in sync with the present time and science. Hence there is a desperate need to bring a new law, and hence we are bringing this law to modernize our investigating agency, so that we can keep a fine check and balance in the society, to maintain a law and order in a better way in the society. On point of sending the said legislation to select committee is concerned, our Home Minister has said that there is no need for such thing, and Government of India has literally paid no heed or attention towards this suggestion of the opposition. Also, our Home Minister assured to the House of Parliament and country that the data is collected under this law and legislation will be stored in a secured mechanism. So if you see, viewers, there are equally forceful arguments from side of government and opposition. So if you like my attempt and effort to bring you the factual insight of daily affairs, you can leave a like button and subscribe my channel. This is it for the day. Thank you.